And still on that story, Justice Binta Nyako of the Federal High Court in Abuja has refused to admit the leader of the proscribed indigenous people of Biafra, IPOB, bail in the terrorism charges against him. The court on Tuesday declined to grant Kanu'S bail on the ground that the earlier application he filed had been refused. Correspondent Kolojo reports that Justice Nyako held that the only option open to Kanu'S was to have gone to Court of Appeal to challenge the earlier refusal. The judge also refused to give unfettered access to just anybody to visit Kanu'S in custody for security reasons. The federal government, however, objected to the request on the ground that Kanu'S was once granted bail but jumped and fled the country. Justice Nyako asked the defendant to proceed to Court of Appeal to ventilate his anger against the early decision of the court rather than coming back with the same request. Meanwhile, the federal government, being represented at the proceedings by Adegboyega Hassan, is pressing for opening of the trial in the terrorism charges. Counsels to Nnamdi, led by Alo Ejimako, faulted the ruling of the court, saying they are being teleguided by the federal government in the unfruitful conversation with their client.
Do not want to call it a travesty of justice because of the respect we had for the judiciary, but we are utterly disappointed that today bail was refused. On what grounds? The Supreme Court on 15 December criticized very severely the revocation of Nnamdi Kanu's bail. In several pages, which we are going to make available to the media, at pages 19, 20, and 21 of Justice Agem's judgment, he even suggested that the impartiality of the trial court in revoking Nnamdi Kanu's bail is suspect.
What happened today is an act of Federal High Court overruling the decision of a Supreme Court. I wanted to get it right. Because the Supreme Court said Nnamdi Kanu never jumped bail, that the court ought not have revoked that bail. On the application of the violator of his right, that is the federal government, you cannot benefit from your own wrong. And we thought that the Supreme Court would have exercised its power under Section 6.
Is almost like an opportunity lost to bring peace, immediate peace, to the southeast. The Supreme Court had given the Federal High Court the opportunity to bring peace to the southeast. And unfortunately, they are toying with that opportunity given to them by the Supreme Court. All that the Federal High Court need was to go back to the ruling of the Supreme Court and follow it.